Good afternoon, and thank you for joining us for an MP webinar covering the Semiannual HR Legislative Update, 2022 Regulatory Alerts and Guidance. I'm Katie Kreider, Marketing Specialist here at MP. For those of you joining us on the webinar for the first time, MP is a full-service human capital management company. We offer a complete suite of products and services to support organizations through the entire employee lifecycle, including recruiting, HR, payroll, benefits administration, time and attendance, and compliance assistance. We support our clients with cutting-edge technical solutions, as well as proactive, reliable service and a deep HR and payroll expertise. At MP, we are wired for HR and help our clients succeed by aligning their people strategy with their business goals. I'm excited to introduce your presenter for today's program, Paul Carelis. Paul has over a decade of experience in the HR consulting space. Working with businesses of all sizes and industries, Paul and his team of certified HR professionals at MP assist clients with compliance, training, and full circle HR guidance and support. Just a few housekeeping issues before we get started here today. If you would like to submit a question during the program, please use the Q&A feature at the bottom of the screen. And as a legal disclaimer, this training is intended for educational and informational purposes. While we hope that you learn a lot today, the information should not be construed as legal advice. We will be sending out the recording of the webinar later today along with the slides. And with that, I'm going to hand the mic off to Paul.
Great. Thank you so much, Katie. Welcome everyone to today's session. Really looking forward to it. As someone who geeks out on all these legislative and employment law updates and all the inner workings of the various agencies, this is something I really enjoy doing. So looking forward to kind of sharing what I've been learning over the last several months with all of you, and hopefully helping to shape your workforces to get the most out of them and also stay compliant at the same time, and hopefully help you prepare for some stuff that might be coming down the pike in the near future. So in terms of what we'll look to cover within the hour, we'll do a general legislative overview, kind of see how the tea leaves are reading in Washington and some other places. We'll go over some recent court rulings. There were some big ones since we last had a semi-annual legislative update in January. We'll do an update on a couple of the federal agencies, especially the Department of Labor, which also includes OSHA, as well as the National Labor Relations Board. We'll talk about some new state laws, so really important, especially if you are multi-state, to make sure that as of July 1st, there were hundreds of new laws across the country in various states that took effect. So we won't go into all of them. We'll go over some highlights, but just a good reminder to check in on those and with a HR professional who can keep you in the loop. And then we'll kind of look and see how things are trending towards the end of this year as we head towards November elections and November ballot questions, and kind of the outlook into 2023 as well. And as Katie mentioned, we'll do our best to leave some time for Q&A. Should you have any questions at all, feel free to use that Q&A function within Zoom. I'll answer what I can on the fly, and if there's anything we need to take back and research further, we will do that and follow up with everyone via email. So let's get right into it. So wanted to start with a quick COVID update, just because as we work with clients in an HR capacity, we're starting to get a lot of calls where people are saying, I went months and months and months without a COVID case, but now all of a sudden I have an employee who's tested positive. I don't remember what to do, or I'm not sure if anything's changed. What do I need to do? So I wanted to quickly just go over that to make sure everyone, in case, hopefully it doesn't, but in case it does happen to you at your workplace, you kind of know what the current CDC guidance is. So before that, just a quick reminder, as it is part of the COVID-related stimulus, the Employee Retention Tax Credit Program is still in play for quarters 2 of 2020 through Q3 of 2021. So even though those quarters have long passed, you can still retroactively go back, should you be eligible, and claim substantial tax credits for those time periods. The first initial quarters of eligibility will start expiring next year. So it is something, if you haven't explored it before, definitely recommend taking a look and seeing if you are indeed eligible. We've worked with hundreds in retention credits, so it is definitely something I advise looking into if you haven't already. And if you'd like our help with it, feel free to reach out. We'd be happy to talk to you. So when it comes to a COVID positive test from an employee in the workplace, the current CDC guidance is as follows. The person who tests positive does need to quarantine for 5 days, and then they'll want to mask for an additional 5 days. But provided that their symptoms have improved or are non-existent, after that 5-day quarantine, they can return to work. They just need to wear a mask for 5 days. So 10 days total of masking and the first 5 quarantine. Now, when it comes to someone who's had an exposure to COVID-19, the protocol will depend on whether they're up to date on vaccines, and you see an asterisk there. And it is a kind of a moving target in terms of that definition. For purposes of this, up to date on vaccines generally means that someone has either received one booster, so if they've received their full dose of the vaccine as well as a booster, then they're, regardless of how long ago it was, as of right now, that's considered up to date. If they've received a full dose of the vaccines but haven't received a booster, for the Pfizer and the Moderna, that second dose would have had to have been within the last 5 months. I think with Johnson & Johnson, it's only 2 months. But if someone isn't boosted and their last dose of their vaccine was more than 5 months ago, then they're not considered up to date on vaccines when it comes to these exposure cases. But assuming someone, let's say they did have the booster, if they were exposed to COVID, no quarantine is required. They will want a mask for 10 days. And if possible, test at day 5 days after they were exposed. But they do not need to miss work as long as they're wearing a mask based on the current CDC guidance. If they are not up to date on their vaccines, similar to the positive test, we will want those folks to quarantine for 5 days and then mask for 5 additional. One interesting thing that just happened within the last couple of weeks, so the Equal Employment Opportunity Commission, if you recall, kind of while we were in the throes of COVID, had given the green light to COVID testing by employers, and basically saying that doesn't hamper on anyone's rights under the Americans with Disabilities Act, and it's not considered a health examination, and just kind of gave the green light to employers to be able to do that. They did make some changes now in their FAQs and in their guidance when it comes to testing, and it kind of remains to be seen until there's a little bit more guidance published in terms of what they mean by it. And they've given a couple examples, but one key change that they made was the question about, is it okay to test our employees for COVID-19? And they're still saying yes, but they're saying provided you can show a business necessity. And some of the examples that they've given as a business necessity is if there's a large amount of community transmission in the area where the employees are working, or if there are highly contagious subvariants in the area, or there is susceptible employee or customer, client, patient population. But they have backed away from just the completely 100% yes, you're okay to test employees for COVID-19 no matter what. Again, the examples that they're providing kind of suggest that you can, in most cases right now, you can make a case that it's still okay, but we'll want to keep an eye on that because they are starting to shift and have some exceptions to that rule. So keep a close eye on that. One question that came in, we'll try to answer these on the fly when we can, so it's relevant to the information that we're sharing. Can we ask employees to provide booster information if we had not gathered this already? Yep, so you can definitely ask employees if they've been boosted. And you can make the argument so that it affects the protocol should someone be exposed to COVID-19. So yes, you can do that. All right. All right, so let's talk about the legislature a little bit. So as of right now, we are months away from the midterm elections. So whenever that happens, you know, outside of very bipartisan agreement on bills, there doesn't tend to be a lot of action. And, we're nearing the end of this legislative session, so there isn't going to be a great deal accomplished between now and November. But there is one, and it does affect many, if not all, businesses. There is some strong bipartisan support for new data privacy law. And this is important in a couple of key ways. So many of us have operations in states that have existing data privacy laws: California, Massachusetts, several others. Most states do at this point. One key provision of this that was negotiated between the Democrats and the Republicans is that this new data privacy law, should it come into effect as currently drafted, would override state laws. So kind of any related state data security laws would kind of go out the window with this new federal rule. So we'll want to get to know it really well. It remains to be seen what, if any, changes will be made to it as currently written. Some of the key provisions in it, it does bar discrimination based on data collected by a business or an entity. So whatever data is collected, cookies, things like that, there are strict provisions prohibiting discrimination based on that data that is collected. There are also lawsuit provisions, so they do allow individuals to sue businesses for data breaches, privacy concerns, inappropriate use of a consumer's data. But in the current form, and again, this could change before it's signed into law, if it ever is signed into law, there is a small business exclusion or exemption from those individual lawsuits. So for those of you who are small businesses, that will likely be a sigh of relief. We'll see where they land in terms of the definition of small businesses, but that is part of the current version of the bill. So that's the biggest thing as we're gearing up. We are going to be doing a follow-up legislative update session in September, where we'll be talking about some of the ballot questions coming up, if any of those pertain to employment law in any way or could affect you as a business. Why we're not talking about those right now is that really, for the first time that I can remember, a lot of employment related, especially ballot questions, are getting challenged in court, and some of them are getting shot down. So there was one in California that got shot down, doesn't appear it's going to end up on the ballot, and also in Massachusetts, which is one that was similar to a recent one in California relating to Uber and Lyft and some of the gig economy, and whether there can be a separate non-independent contractor classification for those workers. The Massachusetts Supreme Court threw that out. They're not allowing it on the ballot. So we'll see where that goes, but we will be doing a special fall update in September on a lot of the stuff we're covering today. One thing outside of the legislature, but we don't have an IRS separate slide on today's presentation like we sometimes do, but I did want to make it important that this month the IRS has increased the standard mileage reimbursement rate. It's up from, I believe, 58.5 cents up to 62.5 cents. So if you do follow the IRS reimbursement rates for mileage, do note that that has increased as of July. Okay. All right, so let's talk about the courts. So there are a lot of Supreme Court cases obviously grabbing the headlines, obviously the abortion most notably, but there have also been cases that do more closely pertain to employment law and HR practices. First of which has to do with military leave. So there was a Supreme Court case involving the state of Texas and a police officer, a state trooper, who went out on USERA, which is military leave, and felt that he was not returned, or that the state basically didn't follow the military leave guidelines. The state felt like they were exempted from that. The Supreme Court decided otherwise. So what that case did is made it clear that individual states, and states are public employers, their employees are protected under USERA and applicable military leave statutes. The second one is a case you probably did hear about, but just wanted to talk about a little bit, as the way the opinion was written, it could have effects on other, at least public sector employers, and we'll see how it's interpreted, but maybe even private sector employers as well. So this was the case involving the high school football coach who was gathering some of his team to pray after games on the field. The court did side with the coach, said he was allowed to do it, and in the opinion, they kind of painted a broader stroke with it to say that, as a rule, employees of public employers are allowed religious expression, provided it doesn't otherwise interfere with their work or be coercive in any way towards any employees or discriminate in any employees, that otherwise employees of public employers are allowed religious expression rights. So as you can imagine, that can pertain in numerous ways. So something to keep an eye on and see what other cases either support or run against that precedent going forward. Another interesting case that the Supreme Court decided not to hear, so basically essentially the plaintiffs lost out, were a couple of cases specific to California, one on behalf of freelance writers and another on behalf of truck drivers. So that AB5 bill that I mentioned a few minutes ago that created a carve out for Uber, Lyft, other certain specifically specified gig and independent contractor workers to not have to be employees, because California basically has the most strict independent contractor rules out there, where it's very, very hard to legitimately classify a worker as an independent contractor. In most cases, they need to be an employee. There was that bill, AB5, which did pass via ballot initiative to allow certain industries and positions to be carved out so that they could maintain a kind of a hybrid independent contractor relationship with some rights not generally awarded to independent contractors. Problem is, it's very specifically defined, so it only pertains to those Uber drivers and a few others expressly mentioned in the bill. And what we're seeing now are there are other groups of workers, in this case freelance writers and long haul owner operator truck drivers, who also want to be included under that hybrid category, or want to just allowed to be independent contractors. They're not allowed under AB5. So basically, California is saying these people have to be treated as employees, and the workers don't like it. They like in these instances, like the freedom of being independent, not being associated with one company, not having to be employed by a company as an employee. But the Supreme Court did not want to hear it. So as of right now, those groups under California law are still considered W-2 employees, whether they like it or not. So we'll see how that plays out, especially if and when other states have similar laws similar to AB5, whether that'll become a further issue for industries and workers not included in however those respective bills shape out. And then lastly, another big Supreme Court case regarding arbitration and mandatory arbitration. So this was a case involving Viking River Cruises, where they had an employee who tried to file suit against the employer, but they had signed an agreement when they started employment saying that they agreed to arbitration and agreed not to sue the business or go through traditional litigation, that they would go through arbitration. So they challenged it, and the Supreme Court did side with Viking River Cruises and said that basically arbitration agreements are lawful, they are enforceable. So if you do utilize arbitration agreements, at least on the basis, if they're similar to the basis of this Supreme Court case, those are indeed valid. So some other big court rulings. These are not at the Supreme Court level. These are at the state or lower courts at the federal level. First of which was in Massachusetts, but I decided to include this just because It was interesting. It was really landmark. Definitely, if you have employees in Massachusetts, you want to pay special attention. But it'll be interesting to see how this is taken by other states as well. So this case had to do with the city of Methuen, Massachusetts, and an employee that they had. They terminated the employee for cause based on an issue with larceny. And there was some accrued but unused vacation that was owed to that employee that was not paid at the time of termination. They did eventually notice that they had that. They did pay it out. I think it was about 3 months after termination, but it was before the employee filed a complaint, a formal legal complaint about the wages. They were paid, and after they were paid, they then made a complaint. The city did offer to provide a payment of interest for the time between the termination and when the 3 months when the amount was paid. But if you are familiar with the Mass Wage Act, there is what's called treble damages. So basically, if you violate the Massachusetts Wage Act, whatever you owed that employee is tripled, plus court costs, and that's generally what you owe to the affected employee or employees. Previous court cases had always sided with the employer that as long as they corrected the action before a complaint was made, that they did not owe treble damages for the entire time period. This case blew that out of the water, where they basically said, yes, even though a complaint had been made, the payment was not made timely, and thus the city owed the employee who was fired due to larceny triple that vacation time plus court costs. So this is really landmark. Really, as an employer takeaway, especially if you're in Massachusetts, if you're terminating someone involuntarily and for whatever reason cannot get them paid at the time of termination, you really want to strategize. You want to do all that you can to pay them at the time of termination. If you can't, you may want to explore your options, which may include putting the employee on a suspension or an administrative leave until you can get that payment at the time of termination. Otherwise, you could potentially be in violation based on this court precedent. I do see a question asking for the names of the Supreme Court cases. You bet. We will include those in our follow-up email. So everyone will get a copy of this recording. They'll get a copy of the slides, and I will include the names of the court cases. My apologies for that. The next was a lawsuit on behalf of the Equal Employment Opportunity Commission against a large McDonald's franchisee in Vermont. So this case was one of the locations had a night manager who was allegedly sexually harassing an employee. This employee did have a disability. They had an accommodation in place that had to do with the hours that they could work. So they were working at nights with this manager. They did come forward once with a complaint to a member of management. No action was taken. The sexual harassment continued. They came forward again. The night manager was placed on a brief administrative leave while they did the investigation, but they then returned him to his management position. At that point, according to the plaintiffs and the EEOC, the company and or the manager then retaliated against that employee, changed their shift, eliminating their reasonable accommodation under the ADA, and essentially forced the employee to quit. I'm not sure of the circumstances of it, but the employee did end up passing away at some point between the termination and when the suit came to the courts. But they were filing on behalf of the estate and some other employees who also came forward and said they were sexually harassed by this manager. And ultimately what happened was there was a settlement that included, among other things, some trainings, a hotline for employees to use if they're being harassed, and trainings for management as well as employees, but as well as a cash settlement of over $1 million. So really the key takeaway here is, a lot of companies are good about understanding that they need to do sexual harassment training, and they focus on training the employees, and that's great. It's good. It is important. But if you're short on time, short on resources, short on money, and you need to focus on a population of your staff to do harassment training with, I strongly urge you to consider focusing on the management team. Because the management team, as agents of your company, the things that they do and the things that they don't do are essentially what you are, as a company, are doing or not doing, and you're really left holding the bag if you have bad actors. So, obviously the manager who was harassing was trouble. You can't always prevent harassment from happening in the workplace, no matter how hard you try. But really, the troubling thing of it is that this employee went to two different other members of management to lodge a complaint, and nothing came of it. So that's really where you want to focus focus the corrective action on. In this case, is that those managers really needed to know how to move that up the food chain, get it in the right hands, ensure that a proper investigation happened, and that proper action was taken based on the findings of that investigation, and B, that they were doing everything within their power to make sure that that employee was not retaliated against, regardless of the outcome of that investigation. So even if they did find that they didn't feel strongly that harassment had occurred, as long as it seemed like a good faith reporting by the employee, they needed to work a lot harder to make sure that that employee wasn't retaliated against. So just a couple of court cases here to keep in mind as you continue to manage your workforce. All right, so over to the National Labor Relations Board. The NLRB did just recently announce a partnership with the Federal Trade Commission focused on any unfair labor practices or employees put in compromising situations. So they haven't gone into too much specifics in terms of what they're specifically going to tackle with this, but they did provide some examples. So this may include looking at non-competes that are one-sided, strong for the company, not strong for the employee. Other types of one-sided contracts or employment agreements that don't really provide any advantage to the workers. And also taking a look at the gig economy, which could include classification, collective bargaining, unionization efforts, things like that. So FTC and the NLRB will be working jointly on some of those items. There is also a controversy over at the NLRB right now where it wasn't a member of the board itself, but the lead general counsel of the NLRB, which is a very powerful position. So basically, that general counsel slot decides which cases the NLRB is going to hear. So the board gives them some direction. They say, we want to take cases on that have to do with this or have to do with that. To be honest, usually it's cases that, it's the same types of cases, and each administration will want to hear those cases so they can kind of change the precedent and change the ruling from the NLRB on what that is, whether it be, employee chilling handbook policies or protected speech by employees, what have you. So in this case, the general counsel of the NLRB said in a statement that, generally speaking, captive audience meetings, and these are when a business is potentially going through a union election or talking about a union election, that they have a meeting that they require everyone to come to, a mandatory meeting, specifically to talk about why unionizing is not going to be a good idea. Those are known as captive audience meetings, and the general counsel has went ahead and said that those are illegal. That's being challenged by other agencies in other states, saying that, based on current rulings in place, those are not illegal. So that's something that's soon to be hashed out by the NLRB, but it'll be important to know in case that's something you do wish to pursue. You'll want to know whether that's kosher according to the National Labor Relations Act or its current interpretation or not. They have also said that they do want to examine the joint employer rule. They may want to make some changes to it. So that comes into play with examples like the McDonald's franchisee. So in that case, based on current joint employer rules, corporate McDonald's is not considered a joint employer of those McDonald's employees of the franchisee. This can also happen with like temporary staffing agencies and things like that. And depending on the circumstances, whether or not those temporary employees are both joint employees of the staffing agency as well as their assignment. The NLRB is examining those rules, and they said they may make changes to that. They are also looking at the union election rules, quickie elections, how long elections are allowed to take, should take, what goes into calling for an election and a certification. They are looking at that, and they are likely to make some changes to that as well. And as those changes happen, we will be sure to let you know. So as you've probably heard if you keep up with the news, it isn't just based on the stories you're hearing. It is true that union activity is skyrocketing. So unionization petitions, which basically means when a union formally files a petition to the National Labor Relations Board to say that they wish to have a union collective bargaining election to decide whether or not the workplace is going to unionize. This year, those petitions are up 56%. And by May, they had already seen as many petitions as they did in all of fiscal year 2021. So it isn't just Starbucks, Amazon, and those. Lots of businesses are talking about unionizing. In accordance with that, the number of unfair labor practice charges that the National Labor Relations Board had filed is also up by 15% this year. So that's over 13,000 unfair labor practice charges have been filed. So that can have to do with a number of things. It always has to do with a perceived violation of the National Labor Relations Act. So that does sometimes have to do with union activity, that a company is chilling an employee's rights to unionize or hold an election. It can also have a looser interpretation. So sometimes you'll see protected speech, that someone was fired for complaining about, going on Facebook and talking with other employees and complaining about their workplace or complaining about their boss. Technically, that can be seen as a violation of the National Labor Relations Act and protected speech. It's all in the vein of, complaining about your workplace as eventually having the right to collectively bargain and unionize. But even if it doesn't have anything to do with unionization, if it's chilling those protected rights, it can be an unfair labor practice under the National Labor Relations Act. We are also starting to see some challenges based on businesses or locations that have decided to unionize and the company's response to that. So this is especially happening with the Starbucks and the Chipotle cases, where there's one case just this week up in Maine where a Chipotle in Maine did vote to unionize that location. And then within a couple weeks, that location, the corporate Chipotle, decided to close down that location. So, they're making the argument that it was a business-related decision. The workers and the union are saying that that was a retaliation because they decided to unionize. So it'll be interesting to see how that one plays out. Also seeing some unfair labor practice when it comes to unionization efforts, charges against Amazon. Again, those are still being heard and moving through the system. We'll see how those pan out. So hearing a lot of union activity about those. One other one that I thought was very interesting was Medieval Times. So the performers of Medieval Times have also voted to unionize in New Jersey at the New Jersey location. So we'll see how that goes. That was a recent development. Medieval Times has said they will act in good faith with those workers, and we'll see how that all plays out. But Medieval Times in New Jersey is now a union workplace. All right, Department of Labor is staying very busy. They have said, and the EEOC has said this too, but they're taking a special eye and really focusing on what they consider vulnerable employee populations. So some examples of that are fast food industry, the restaurant industry as a whole. They recently just went after Taco Bell locations for some overtime violations. They're also going after retailers. There are several instances of this. There was a place called T-Shirt Factory, which is located on a beach, and they kind of provide to beach tourist t-shirts, but they had people they were paying under the table, people that they were paying much later than they were supposed to under state and federal laws. They weren't paying overtime, so that was a six-figure settlement by the Department of Labor. They're also currently investigating an Amazon warehouse in relation to some of their OSHA and safety complaints that they've seen from warehouses. So they are doing a lot of warehouse inspections. And they're also doing a big focus on the healthcare industry, both from a wage and hour perspective, as well as their OSHA arm for safety practices, especially with COVID-19. Over in OSHA, which is technically a part of the Department of Labor, they have announced that for the construction industry, they are now doing some surprise weekend inspections. So that is specific to the construction industry, but they are doing those. They're also dedicating at least 15% of their inspections to the healthcare industry. So as of right now, the top three industries for DOL and OSHA inspections are construction number 1, manufacturing number 2, and healthcare number 3. And to date, this year, they've already conducted more inspections across all industries than they had in all of 2021. OSHA is also working on developing some standardized heat standards for workers who work in hot conditions. So if you're in the same part of the country as me, that's very understandable at the moment where temperatures are approaching 100 degrees. OSHA is working on a permanent heat working standard. They are also potentially looking at expanding the employers in certain high-risk industries who are required to report their 300A log, which is a summary of all OSHA incidents over the previous year, as well as perhaps including the OSHA 300 log, which is a more detailed reporting as well, and not just the summary. So as of right now, employers in certain high-risk industries who have more than 250 employees are required to electronically submit their summary or their 300A log to OSHA with all the reportable OSHA incidents over the previous year. If OSHA proceeds as proposed, that threshold will go from 250 employees to employers with 100 or more employees in certain high-risk industries, and then will also, if they move forward as proposed, also include electronic filing of the 300 log, which is a more detailed, where you kind of list out all of the OSHA incidents that happened with a little bit more detail than the summary page requires. So we'll keep you updated on that as well. We have also heard a pretty reliable rumor that the Department of Labor is going to come out with a new proposed changes to the Fair Labor Standards Act as it pertains to which employees are allowed to be exempt versus those who are going to be non-exempt and eligible for overtime, record keeping, and other provisions of the Fair Labor Standards Act. So these proposed rules certainly involve a change to the salary test, meaning what's the minimum amount of salary that an employee has to be paid to be considered exempt in addition to their job duties. So that number is expected to go up. It's unclear right now if they're going to change the duties test as well in terms of what job duties an employee has to primarily have to be considered exempt, but we will be seeing that in a couple of months. And through the Department of Labor rulemaking process, so there'll be a proposed rule. There'll then be a public comment period where people can submit opinions on the proposed rule. There'll be some listening sessions, and then a final rule will come out with an active date. So based on the length of time that takes, with the proposed rule coming out in October, it won't be until 2023 and maybe even 2024 before that officially takes effect. But it is, again, going to be something important that could potentially affect every employer in the country. So you're going to want to keep a close eye on that one as well. All right, so over in the States, there have been some updates to the minimum wage laws in several states. Whoops. So for the states you see on the screen without an asterisk, that's a statewide minimum wage increase. Some other states Where you see the asterisks, it's either at the county level or city level. So if you see your state where you have employees in there with an asterisk, you just want to double check or reach out to us to find out specifically which cities and which counties did have a minimum wage increase. Please note that just about all of these were July 1st, so these are now in effect, these minimum wage increases that you see on the screen. There are also several states who have passed non-compete laws taking effect as of this month. So it varies state by state, but you will see various states put various restrictions on non-compete agreements. So most of them aren't outright bans, but they are restrictions on who is allowed to have a non-compete agreement in place. If you have any employees in Maine, you will want to note that as of next month, if they have accrued unused vacation time, that is going to start being required to be paid out at termination. Also, if you have employees in New Mexico, there is a new mandatory sick leave that you need to provide to your employees there. So many states are still wrapping up their legislative sessions for the year. Our September webinar will cover a lot of what was accomplished or not accomplished as those legislative sessions come to a close. New York has an earlier close to their legislative session. It actually closed last month, and they were very busy as the deadline approached. So some important employment law related items that did pass in New York. One of which was contracts for freelancers. So freelance workers in the state of New York do now essentially have a Bill of Rights where there is a contract with certain provisions that have to be included that need to be provided to anyone in New York you're paying as a freelancer. They did also pass a law that provides protection for lawful absences. So when employees miss work because of a legally protected leave, either at the federal, state, or local level, you cannot, if you have like a attendance policy or anything else that adds up points for absences or things like that, in New York you are not allowed to have those legally protected absences count against them. There is also a law pertaining to warehouses and productivity and what you're allowed to monitor and what you're allowed to require in terms of warehouse productivity by warehouse workers. And there is also a law pertaining to nurses prohibiting mandatory overtime except when there are public health emergencies. So if you do have employees and you do fall under any of those industries within the state of New York, you want to make sure you're working with an HR professional who can familiarize you with those provisions. Okay. Looking ahead. So in terms of what we're seeing out there for other litigation trends, definitely a lot with those arbitration and severance agreements and really holding employees to those. Again, so far, the Supreme Court has withheld those types of things, saying that, yeah, if you signed a document that says you need to go to arbitration, then you need to. Or if you're prevented from doing something as part of a severance agreement you signed, then you are held to it. But those are continuing to flood the court. So we'll see how those, if and when that changes. We are also seeing, as I said before, a lot of claims of union busting, retaliation against people attempting to unionize within their rights, all of that fun stuff. Also, a lot of lawsuits pertaining to wage and hour, overtime payments, whether or not overtime, was paid correctly, was included all of the remuneration that's required to come as part of overtime. Employee misclassification, that someone should have been eligible for overtime and wasn't paid it, or they were paid as an independent contractor when they should have been an employee, as well as remote work lawsuits that people were working more than they were being paid for, that they're working from a state and that the employer wasn't following the labor laws in that state because they were working from it remotely. And then a lot of lawsuits regarding accommodation, so that an employee made a request, they had a disability, there was a reasonable accommodation available, and the business refused to provide it. So, some things to look for. Definitely the November ballot questions, which ones end up being allowed on the ballots, which ones get shot down. Again, we'll talk about that in September. Further action on independent contractors and freelancers. Many states are taking a look at those rules. The Federal Department of Labor has also said they're looking at that, so we could see a across the board limitation on independent contractors coming soon. You're going to want to keep a close eye. So as more and more workers and more workplaces are looking to unionize, so as of right now, it's still only about 10% of the workforce that's unionized. It's at an right near the all-time low compared to decades ago. But we are seeing a lot more activity there. So you're going to want to make sure that if the National Labor Relations Board does make a ruling and does change the rules, that when you do have potential union activity happening at your workplace, that you are following the current rules on that. And similarly, when the National Labor Relations Board relaxes or creates more empowerment for employees, that also tends to go hand in hand with language in handbooks, and that even if it is a policy that doesn't pertain to unionization, if it's say, what employees are allowed to do or say, or what's considered confidential information or solicitation in the workplace policies, you're going to want to make sure that those policies are written in a way that speaks to the current climate and the current allowed language based on the current interpretations of the National Labor Relations Act. All right, so let's see. We do have a couple more questions here. We answered the booster one. Is New York State's COVID pay still required? Yes, unless anything changed at the end of the legislative session, which I don't believe it did. I didn't read anything about it. There is still COVID sick leave in New York State, yes, but it's one of the only places that does have it. At the federal level, it is no longer in place, and in most states it is not in place, but in New York it is. Okay. What is the vacation payout law for Massachusetts? So Massachusetts has one of the more liberal vacation payout laws in the country. Anything that is considered vacation does need to be paid out at termination, whether that termination is voluntary or involuntary. Anything that's accrued but unused. If you use a general PTO policy, so you don't separate out sick and vacation, then that would need to all be paid out. If you do separate vacation and sick, you only need to pay out the vacation. You don't need to pay out the sick. If you have further questions on that, please let us know. What states currently have non-compete limitations? Let me work with our team to compile that list. It's a lengthy one at this point, but we can get that out to everybody. How would something like an alcohol or brewery company that has both production and manufacturing work, as well as employees with retail and service employees in front of house roles, fall into the vulnerable employee population? So generally how that's being viewed by the Department of Labor is they're going by the NAICS code. So whatever your NAICS code is, so basically how you file with the government in terms of what your industry is, that's what they're going by. So a lot of businesses do have workers in all different kinds of classifications. It all has to do with your NAICS code in terms of when the Department of Labor or a federal agency is doing a campaign, that's what they're going by when they're targeting a certain industry. And one closing remark here. Oh, it looks like I have some more questions coming in. Again, a lot of times, I think we've fallen victim to the boy who cried wolf syndrome, where a lot of times agencies have said, hey, we're going to focus on this, we're going to focus on that, we're going to go after this really hard, and then they never really do it, because a lot of times it's a department head or a president or someone who isn't in the weeds saying these things, and then when it comes down to it, these agencies are maxed out, they're understaffed, they're stressed out, and they just don't have the boots on the ground to be able to actually follow through on these campaigns. These agencies are staffing up, with the exception of the IRS, who's still struggling to and is way behind. A lot of these other agencies, Department of Labor, OSHA, all of that, they have been able to staff up. So they do now have the resources at their disposal, and they are following through on their promises on these campaigns. So when you hear a federal agency now saying that they're going to go after something or take a look at something, I would tend to believe it as we are seeing that happen. Yes, we will be providing a recording of today's presentation. What are states are required to pay out vacation at termination? Again, that's tricky. It's a little more complex than we would be able to answer live. Some states require it across the board. Some states only require it if your policy says that it is going to happen, or doesn't have a policy saying that you won't do it. Other states will allow it, under certain circumstances. So that is a complex one, but if you are a multi-state employer, it is a good idea to reach out to to an HR professional that you trust who can kind of break it down state by state for you. So it looks like those are our questions for right now. I thank you very much for your time today. Again, this is something I love talking about, and I do apologize for not including the names of the Supreme Court cases. We will get those to you along with the slides and along with the recording of today. But with that, I hope you all have a great day. If you're in a area of the country that's as hot as it is for me, I hope you're able to stay cool. But otherwise, I'll hand it back over to Katie.
Thanks so much, Paul. So much valuable information. The MPHR team is here to help guide your organization on any HR compliance issues. If you would like to learn more about how we can assist your organization, please visit our website to set up a short 15-minute call. Be sure to join us next week for our webinar on unionization 2022, updates and compliance guidelines for employers. Visit our website to register and to see the full calendar of upcoming events and available resources. We will be sending out a recording of the webinar with the presentation slides this afternoon. Thanks for joining us and have a terrific day.